Yes.
So I thought we'd take that up before I brought the jury in and had to send them back out.
Yes, Judge. The state intends to introduce a certified copy of the order from the Circuit Court in Bristol, Virginia, which ordered Hunter Wood involuntarily committed to the mental hospital over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a letter dated January 10th, 2025, which is from the Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the Circuit Court in Bristol, Virginia.
We have no objection, Judge.
Okay. So what I intend to do, then after that, do you think you'll have any other proof?
No, Your Honor.
So what I'll do is I'll bring the jury in, admit that, and as the next number to exhibit, then you can rest in front of the jury. And then I'll have to send them back out so we can take up some matters out of their presence. All right, we can bring the jury in if we're ready.
Everyone stand, please. You may be seated. Thank you.
All right, General, call your name. Oh, wait, before you do that. Ladies and gentlemen, yesterday when we left, I gave you certain admonitions. Do any of the jurors have anything to report with regard to those admonitions? If you do, raise your hand. Let the record reflect that none of the jurors raised their hand. All right, General.
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. And we would offer that as the next exhibit in this case. 261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit 261. All right, call you next.
Judge, the state would rest.
All right, ladies and gentlemen, I know you've only been out here for 2.5 minutes, but I'm going to send you with the officer for a few minutes.
Everyone stand, please. You may be seated. Thank you.
Mr. Scott, you have a motion?
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts. Just briefly, I'll go through them. As it relates to the first 3 homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various although she stated that she believed it was a asphyxia, she later, under cross-examination, admitted it could have been a SIDS death. She admitted that it could have been a heart issue, or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count 1 and premeditation, there is no evidence whatsoever in this case of premeditation. So those are the 3 murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect its health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion. False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those, but I will leave those for now, but I do move for a judgment of acquittal without further argument. And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
I'll be brief, Judge. Of course, the court reviews this motion in the viewing the evidence in the light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket, and then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation is at least shown through the physical evidence in this case. As far as the remaining counts showing the cause of death, both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
All right. Of course, as Mr. Scott and the gentleman has stated, in viewing the evidence in light of the Rule 29 motion for judgment of acquittal, the court's required to view the evidence in the light most positive to the state. And looking at these charges and the proof through that lens, with regard to count 1, the premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, we couple that with the voluminous amount of evidence where the defendant was given different stories as to where the child was, as to how the child was doing. When you look at that count in light of statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that date, there was story after story about where the child was. The defendant appeared to have moved on to other things. And I think when you take all that evidence and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But the courts of the opinion the state, when looking at that proof in light most favorable to the state, that they have put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think that taken in light most favorable to the state, the fact that that child was wrapped and placed in the garbage can, I think the jury can look at that. And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy, dirty toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. And I think that taking the light most favorable to the state, that those two counts would survive the Rule 29 motion. And I'm going to deny the motion with regard to those two counts as well. With regard to the tampering with evidence and false report charges, as well as the abuse of the corpse and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in the light most favorable to the state, I think those are issues the jury can determine and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right. In that case, we have to go through the Moen versus State questioning, and I'm going to hand this down and let you do that.
Judge, for the purposes of the record, would you like her to come to the...
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr.
Megan, I want to ask you some questions about my representation of you and explaining to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes.
Okay. And part of that, I've talked to you about you have the right to testify. Is that right?
Yes.
And if the jury can't hold it against you if you don't testify, do you understand that?
Yes.
Do you understand you have a right not to testify?
Yes.
Okay. And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
Yes.
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
Yes, I have.
Do you want to testify?
No.
I think I've covered it, Judge. Approach.
Yeah. All right. We got other proof?
No.
No? I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I gotta send the jury out so we can finalize the charge and give the parties time. Because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them nod off if they're reading with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we'll bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I will finalize it and send it out to the jury. That's the
Yes, sir.
process going forward. And here in this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for closing argument. Okay? So we need to bring the jury. And I need to give the curative instruction about.
Yes, sir. I was going to ask about that. I forgot.
I did too.
Everyone stand, please. You may be seated. Thank you.
All right. Okay, ladies and gentlemen, one thing I omitted to do a moment ago. Yesterday, during Dr. Malushnik, did I say that right?
Yes, sir.
At the very end of her testimony, she answered a question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? Yes, sir. I'm going to instruct you that last phrase, you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Yes. Everybody puts that murder in some other way out of their mind and not consider it. If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Defendant rests.
All right. Ladies and gentlemen, where we are now is the proof is closed, but it is not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow along, and you'll have that for your reference while you deliberate. Okay? This will also, what will happen is it'll probably take 45 minutes to an hour. I'll get all the notebooks made. We'll give the lawyers time to organize their thoughts for closing. When we come back, I will hand out the notebooks and I will read you the charge, which will be painful, and I apologize for that, but that's the way it is. And then we'll go straight into argument. Okay? So I apologize for the length of the break, but just bear with me. It's necessary. Okay? You'll go with the officer.
Everyone stand, please. You may be seated, thank you.
All right, we'll be in recess. We'll probably take 45 minutes.
Court stands in recess.